A federal judge just did something USCIS did not want to happen. If your green card, work permit, asylum, or citizenship case has been sitting frozen since late last year, this ruling is the reason why, and it may finally be over. A court has ordered USCIS to end its hold on green cards, work permits, asylum claims, and citizenship applications for people from 39 countries, effective immediately. In this video, we will walk you through exactly what happened, who this affects, and what steps you need to take next, so stay with us until the end for the full picture. If this video helps, tap the bell, subscribe, and like it for future immigration updates. That way, updates can reach your phone directly, more quickly. Let's begin with the background first. Here is a closer look at how this case developed. In December 2025, after a shooting involving a foreign national in Washington, D.C., the administration introduced a set of policies that quietly paused immigration benefits for nationals of countries placed on an expanded travel ban list to start. By January 2026, that list had expanded to 39 countries, covering parts of Africa, Asia, the Middle East, and Latin America. Under those rules, USCIS stopped making decisions on green cards, work permits, naturalization, and asylum applications for people from those countries. Officials also ordered benefits that had already been approved to be reviewed again, and told officers to treat nationality as what they described as a major negative factor in discretionary decisions. This is general immigration information only. On June 5, 2026, Chief U.S. District Judge John McConnell of the District of Rhode Island issued a broad ruling in a case called Dorsis International Institute of Rhode Island versus USCIS. In a detailed opinion, Judge McConnell said the agency had no legal power to suspend application processing indefinitely just because of someone's birthplace, as federal law requires. According to reports, the judge said the policy left many immigrants waiting for months with no explanation, and that the delays could not be blamed on anything the applicants themselves had done wrong in those pending cases at all. The court found that the policies violated the Administrative Procedure Act in several ways, including USCIS skipping notice and comment, acting beyond the authority Congress gave it, and failing to provide a reasoned explanation for those actions it took here. So, what does this mean for pending cases exactly today? In practical terms, the ruling wiped out 4 separate USCIS policies: the blanket pause on benefit requests, the global asylum hold, the re-review of already approved cases, and the rule that treated nationality as a negative factor altogether. These are the groups most directly affected here. Green card applicants filing Form I-485, the application to register permanent residence or adjust status, whose cases stalled after December 2025. Work permit applicants and holders using Form I-765, the employment authorization application, many of whom lost jobs when their authorization expired and could not be renewed at all. Asylum seekers whose affirmative USCIS applications had gone completely quiet, and naturalization applicants whose citizenship interviews and oath ceremonies were quietly delayed instead. Immigration experts say this case affected an enormous number of people overall. Reports say the freeze affected over 2 million applications since it began nationwide. For families who had already spent years on paperwork, biometrics, and interviews, only to see their case go silent without explanation, this ruling is real relief now. If you are a green card applicant or work permit holder from one of these 39 countries, this can feel overwhelming, especially after months of uncertainty about your job, your status, and your ability to plan for the future. Although some details have changed since the ruling, the situation is still moving quickly now. On June 11th, the court entered final judgment for the plaintiffs in full. USCIS then posted a public notice saying the vacated policies should be treated as no longer in effect agency-wide. Still, advocacy groups including the Dorcas International Institute of Rhode Island and African Communities filed an emergency motion days later, saying USCIS was still applying the same policies the court had just struck down throughout the agency too. They said people were still being denied green cards, citizenship, and work permits even after the ruling. In response, the judge issued a follow-up order requiring the agency to comply at once, including notifying staff about the ruling and updating public guidance. Even so, the fight is not over yet. On June 12, the government filed a notice of appeal, sending the case to the First Circuit Court of Appeals. Then on June 19, the administration asked the district court to pause its ruling while that appeal moves forward, citing national security and vetting concerns for the record. The plaintiffs had until July 6 to respond, and, as of this recording, no stay has been granted yet. Legal analysts say that if the district court or the First Circuit grants a stay, the freeze could be reinstated while the appeal continues ahead. If the courts deny a stay, the government could still take the request to the Supreme Court's emergency docket directly. Advocacy groups warn that this back and forth means the current relief window, while real, may not last for long. It is also important to understand what this decision does not change for now. The court did not strike down the president's underlying travel ban itself, and it did not reopen visa processing at U.S. consulates abroad. Separate State Department limits on immigrant visa issuance for nationals of a broader list of countries remain fully in place and are not touched by this case. This ruling applies specifically to USCIS adjudications inside the United States, not to overseas visa stamping abroad. So, if your case involves a consular interview abroad instead of a domestically filed application, this ruling may not alter your timeline much. Officials say individualized review should now resume for affected applicants, meaning cases should be judged on their own facts, rather than blocked by a blanket nationality-based policy on an individual basis moving forward. That does not guarantee approval. The ruling requires USCIS to make decisions, not to approve every case automatically. If your case was frozen, log into your USCIS online account and check your receipt number for any new updates on your file today. If your case has shown no movement since late 2025, it may now be ready to move forward. Make sure your supporting evidence is current, including updated financial records, relationship documents for family-based cases, and any medical exams that may have expired while your file was on hold. If your work permit expired, file a renewal as soon as you are eligible and keep proof of the filing. Because this situation keeps shifting quickly, staying informed matters more than ever for families today. Watch official USCIS announcements instead of relying on social media summaries. And if your case has been stalled for an unusually long time, it may be worth speaking with an immigration attorney about your options, including whether a mandamus action to compel a decision makes sense for your situation. That is all we have for today. This channel shares visa information and procedures for your U.S. immigration journey. It helps explain United States immigration processing steps, visa requirements, processing times, forms, fees, and related details clearly for applicants. We will continue sharing information about U.S. visitor visas, such as B1 and B2, work visas, such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas too, today. Thank you for joining us today, and we will see you next video soon. If you have not subscribed yet, please like, comment, and subscribe for more U.S. immigration updates soon.